Hey, chat. Good afternoon, everybody. Schedule cleared up a little bit, so I thought we'd take advantage of this today and go over the Trump case that came out last night while we were in the middle of the Thursday night show. There's Karen Reed stuff to come. Yes, the Alberts and the McCags have dropped interviews. Those we'll be able to go over. We also can go over what Alan Jackson told Howie Carr. That stuff's all coming up. Just not right now. Just not right now. Did I get the blue shirt from Kurt? No, thank you. I did not. Parallax, it's good to see you, man. It's been a little while. So, but no, today we are going to look at the issue was all about what's going on in California. So, guys, if you remember, about 2 weeks ago, ICE did a raid on a chicken processing factory, and the community showed up and basically kind of boxed them into the property. The FBI had to show up to help, basically the SWAT team, to get the protesters out of the way so they could keep doing their job. People then assaulted the detention center that was being used and attacked it and put things in such a way that they attacked it pretty substantially. Not like Portland, but still, I mean, they were definitely doing their thing at the place. So what happened? Well, ICE said we can't do our job. And Trump said, well, if you can't do your job, I could federalize the National Guard because at that point, the LAPD was not helping protect anything because Karen Bass is not supportive of Trump's policies for immigration. So he federalized the National Guard under Title 10 of the United States Code and have them now, along with Marine units, protecting federal buildings and doing site security. Well, Gavin Newsome, being the commander of the California National Guard, sought a protection order in San Francisco out of a district court. Notice he didn't even go to the place where it was happening, but he went to the Northern District of California and got a protection order, a restraining order, saying, this isn't right. And the judge enjoined Trump from using the National Guard. Literally, a judge tried to do that. So how did that work? Well, it didn't work that way. So what now do we have? Well, we have the aftermath of that, and we'll get to that about what happened. But for now, we're just going to address what happened here as far as things are concerned. We covered the Ninth Circuit addressing the arguments for stay. We covered those a couple days ago. Well, now we've got the opinion from the Ninth Circuit. So let's get into this. And yes, we will discuss what the trial court judge did in the meantime. But first, let's get to what happened in the Ninth Circuit. So this is the Ninth Circuit. This is their filing. It's not as fancy as some of the other circuit courts. We've seen that before. Every court's different. They get to do stuff however they want. June 19th. So filed on Juneteenth. It's Gavin Newsome versus Donald John Trump. And an appeal out of the Northern District of California from Judge Charles Breyer. And some of you might say, well, wait, hold on. How does that work? We had a Supreme Court justice named Breyer. Yes, we had Stephen Breyer, former justice of the Supreme Court, retired in 2022. And this is his younger brother. Now, you might say, well, how old is this guy? Well, he's 83, and his older brother, Stephen Breyer, is 86. But they are both alive, and yes, it is that Judge Breyer. The ones you would have seen before, you're like, hold on there. Tuesret says, can we listen to the jury? Yeah, we will listen. We'll do all the Karen Reed stuff all at once, just not right now. But yes, we'll do all the Karen Reed stuff again. So, but yes, Judge Charles Breyer is similar. Stephen Breyer was appointed by Bill Clinton to the United States Supreme Court. And Charles Breyer, was also nominated by Bill Clinton to the Northern District of California. this is something that he has been involved in there. Have White Claws been acquired? Maybe for later, guys. It's during the day. It's a little early to have some road pops. So we're not going to do that. So here we go. And I just want to address X. A lot of people are like, wait, is it the same guy? Same family. Same family. So per curiam, they all agree. They all agree. And they say under Title 10 USC, United States Code 12406, and this is what when you hear National Guard people talk about Title 10, that's what they mean in Guard parlance. So there's Title 10 and there's Title 32. Those are different frameworks regarding the National Guard and their responsibilities. Title 32 orders are like when the Guard is under state control. Title 10 is federal control. So that's if you ever talk to Guard members, that's how they'll explain things. I'm under Title 10, I'm under Title 32. Title 10 is when you're federalized, you can get deployed. Title 32 is when you're normally doing your regular National Guard stuff and the governor can call you up. So we're going to keep going here, but I wanted to make sure you guys understood that. So it authorizes the president to call in federal service members of the National Guard of any state when one or more of three conditions are satisfied. So one or more of them, just one is enough. So in result of the LA stuff, he ordered 4,000 members into federal service for 60 days. Gavin Newsome sued the president, and they claim that the actions were ultra vires, meaning outside of his authority. It violated the 10th Amendment. Once again, hilarious to see Gavin Newsome arguing about the 10th Amendment. They argue that also this violated the Administrative Procedures Act. And they sought a temporary restraining order. And it was to enjoin them from deploying any members of the Guard in LA. And to order the control of the National Guard returned to Governor Newsome. The district court said that they concluded the plaintiffs were likely to succeed on their claims because the president's order is ultra vires because none of the predicates exist and because the federalization order was not issued through the governor. And they argue that if validly federalized, they may be deployed to protect personnel and property. The plaintiffs could see that. Trump could do this if it was properly done. The district court determined that the plaintiffs were presented no evidence that the TRO here and the National Guard members were engaged in any activities, and the plaintiffs do not contest that determination. So notice, Gavin Newsom's like, well, we have no evidence that they're doing anything but this. So the defendants immediately appealed, and we issued an administrative stay till we could have our arguments. And it says, we now grant the stay. So they're actually agreeing we're putting that all on hold. The defendants have made the required strong showing that they are likely to succeed on the merits of their appeal. They say, we disagree with the primary argument the president's decision under Title 10 is completely insulated from judicial review. Now, remember, chat, they had that discussion saying, well, can we review it at all? And he said, no, you can't review it at all. If the president says that's it. Now, there are times where you have judicial question or political questions and the court can't get involved. This is not one of them, though. And more importantly, it just makes sense. You have the right, the courts have the right to evaluate whether or not your decision was valid or like you properly invoked it. Not necessarily did you apply it properly, but did you have the right to actually make that decision? So it's not a problem here. And I don't disagree with the court. I think that's 100% correct. It's 100% correct there. I agree. They say, nonetheless, regardless of that, we're persuaded under longstanding precedent interpreting the statutory predecessor to 12406. Our review of that decision must be highly deferential. And this gets into Article 2 issues, guys. Remember, Trump is the commander-in-chief of the military. So they're being highly deferential to these issues that tread on his territory. And they say, affording that deference, we conclude it is likely that Trump lawfully exercised statutory authority under Section 3, which is allowing federalization when the president is unable with regular forces to execute the laws of the U.S. They say, additionally, The transmittal of the order to the adjutant general. Remember, guys, the adjutant general is the person who controls and orders around the National Guard. He's the top general. He issues all orders in the name of the governor. Likely satisfied the procedural requirements that federalization orders be issued through the governor. And even if there was a procedural violation, that would not justify the scope or relief provided by the TRO. Meaning, if that was wrong, we're not just going to throw the whole thing out. That's way too much. We could say, hey, maybe you have to redo it. Maybe you have to reformulate things. That would be the proper answer, not a complete taking of an axe to it and chopping it apart. Using the scalpel, not the sword. They say the conclusion is likely that Trump's orders were authorized under 12406 subsection 3. It also resolved the 10th Amendment claim because the parties agree the 10th Amendment claims are attached to the statutory claim. So they also conclude the other state factors, the irreparable harm, all of this, the injury to plaintiffs, and the public interest all weigh in the defendant's favor. So not only are they saying he's likely to win, there's irreparable harm that's in his favor, the injury of the plaintiffs is in Trump's favor, and the public interest is in Trump's favor. That's 4, guys. That's 4 things. And remember, that's 4 out of 4 support Trump. So there you go. Now, as we talk about this, on June 6th, ICE did a raid. And then later that evening, protesters gathered at the Enforcement and Removal Operations building in L.A. The protesters pinned down the Federal Protective Service officers, and they were throwing concrete chunks, bottles of liquid, and other objects. The LAPD arrived on scene about an hour after being called, and the protesters eventually dispersed. But the federal building had been heavily vandalized. Yeah. So as we go through all of this, they talk about what's going on there, and things keep on going for multiple days. And they say in response to this, he signed a memorandum on June 7th calling up 2,000 National Guard members. And what did he want them to do? To protect ICE and other U.S. government personnel from performing their functions, including the enforcement of law and to protect federal property, which he has the right to protect. Later that day, the Secretary of Defense sent a memorandum to the Adjutant General to effectuate it. It enclosed a copy of the memorandum. The Secretary's memorandum called into service 2,000 Guard members for 60 days. The Adjutant General then sent both memorandum on to Gavin Newsome. So the head of the California National Guard, like a good soldier, passed his orders along to his superior, his commander, which is Gavin Newsome. They say the protest continued into June 8th. Lighting fires, vandalizing dozens of buildings with graffiti, including the federal courthouse. They talk about June 9th, 1,000 protesters gathered near a federal building. One protester drove by the building and fired paintballs at the protective service officers, hitting at least one in the head and neck. At another federal building, protesters attacked a federal van carrying multiple non-citizens and officers, meaning ICE members doing their job, rocking the vehicle and smashing the windows, which, trying to rescue these guys and stop them from getting deported, showering them broken glass is probably not what they want. I'm sure that they don't like getting cut up and having glass in their face. But hey, what do I know? What do I know, chat? What do I know? Says the building had to be closed for most of the day and remain closed. It disrupted many federal agencies working in the building. Remember, it's not just ICE that works in the building. On June 9th, they called up another 2,000 members. And that same day, plaintiffs filed their lawsuits that are ultra-virus, the 10th Amendment, and the Administrative Procedures Act claims. On June 10th, they moved for a TRO. They asserted they were likely to suffer several types of harm. As a direct result, they argued the Guard serves only to spread fear and heighten tensions in L.A. and would destabilize the community. They also argued that diverting the National Guard removes state resources because they fight forest fires, stop drug trafficking, and protect against cyber threats. Now, in California and the border states, but California especially, their Guard is trained. They have units that are trained to be involved in combating drug trafficking. Remember, They're on the border, and it makes sense that they're allowed to do that. They also have units that are trained in wildland fighting, forest fighting, because, hey, firefighting in the woods is not easy, and it's a complex thing. So they've got crews trained for it, because guess what? They have 1 million forest fires every year. So now, obviously, Trump opposed the motion, and the district court held a hearing, and it says, responding to the argument that the decision was non-justiciable, the district court concluded that neither the political question doctrine nor 12406 itself precluded judicial review, but that it must give deference to the president's factual assertions. And they say on the merits of the ultra vires claim, they argued whether Trump had authority to do this. And the district court determined that the plaintiffs were likely to succeed on their ultra vires claim because conditions were not satisfied to federalize, and because federalization orders were not done through the governor. And they say, based on its conclusion, the president acted without authority, and also concluded the 10th Amendment claim is likely to succeed. So the court declined to address the ultra vires claims based on the Posse Comitatus Act, and that's using the military for law enforcement purposes, because the plaintiffs conceded that using federal forces to protect personnel and property, and this is going to be important, using federal forces to protect personnel and property would not violate the Posse Comitatus Act. And because the plaintiffs presented no evidence that National Guard members were engaged in any other activities, the district court underscored that plaintiffs did not yet contend the National Guard members have, in fact, participated in any arrest. Now, this is important. The court's clarifying some things here. They're saying the plaintiffs did not rely on the APA in seeking the TRO. That's important. They said the plaintiffs had not argued the president invoked only one subsection, or, how does this work? Was it only one subsection or the other? So there are some problems with the plaintiff's arguments. Gavin Newsome didn't fully argue this in a way that makes sense. Stop yawning. Well, you could suffer. Yes. And now, yes, we'll get to the Breyer stuff, guys. So they argued the plaintiffs continue to pursue the claim, including by presenting additional evidence at the upcoming preliminary injunction. And remember, guys, temporary restraining order can become a preliminary injunction. So they say, though, that the plaintiffs have suffered irreparable injury, and they say that, while the defendants have an interest in protecting federal agents and property, the agents and property may actually well be served by demilitarization and a concurring de-escalation. The district court concluded the deployment of the Guard inflames tensions with protesters and deprives the state for 2 months of its own use of thousands of National Guard members to fight fires and combat the fentanyl trade and for other critical functions. But you know what? How the hell do you know that? How do you know it's going to inflame the tensions? How do you know that? How do you know they're not going to be needed for nothing? Maybe there's no forest fires this summer. Maybe they're smaller. Maybe they're in places they can't do anything about, and we have to send in like the water planes and water bomb it. You don't know. So both these points are extremely speculative. And you're like, why aren't we doing it the right way? But it is what it is, guys. It's California. They're going to do what they want, including the federal judges. So the district court's ordered temporary enjoyment with no end date. And notice, with no end date, meaning forever at this rate. Forever. Forever. Forever and ever. That this could last forever. From deploying members of the National Guard in Los Angeles and directed the defendants to return control. Anyways, so they gave him a time, but Trump sought immediate appeal. And now here we are. So they talk about appellate jurisdiction. They say ordinarily we lack jurisdiction over a TRO. At this time, we're not considering appeal of a TRO, but rather the defendant's motion for a stay of the TRO pending appeal. And we have jurisdictions to grant a stay under the All Writs Act of 28 U.S.C. 1651. So you are allowed to seek You're allowed to seek this pause. You can't challenge the TRO, but you can pause it. And that is what the court is allowing here. And chat, give me 1 second. I have to go to the bathroom, so I'll be right back. All right, chat, we're back. No, Clyde is in the meeting with 2.0 right now. They're having a meeting. They're having an office meeting. So Clyde is not free. He is sitting there diligently assisting 2.0 take notes. So I can't bring him in, sadly. I'm so sorry. He's a good boy. Did I wash my hands? Yes, I did. Hold on. Is this water? Yeah, it's water. Yes. No, 2.0 is not an HR lady. Thank you very much. No, she is actually very important. She does a lot of program. There's a lot of projects she's working on. So Clyde might need rescue. No, he helps. He helps those people. So, all right, we're going to keep moving here, chat. And they say, nonetheless, the plaintiffs argue we shouldn't grant the stay because there are serious questions as to whether we would have jurisdiction to review the issuance of a TRO. They say that goes to the merits of a motion to stay, not our jurisdiction. They say, as noted, we generally like jurisdiction over a TRO, but when the TRO possesses the qualities of a preliminary injunction, it is reviewable. And why is part of it an injunction, chat? Because of this. No end date. That makes it an injunction. It's permanent, which, Judge Breyer, you played yourself. So they're allowed to do this. They say, when assessing whether a TRO is best construed as an appealable preliminary injunction, we evaluate whether an adversarial hearing has been held and whether the court's basis was strongly challenged. And likewise, the duration of the order exceeds the ordinary duration for TROs as set forth. Well, there you go. A TRO may also be appealable when it has the practical effect of granting or denying an injunction. And here it's an injunction. The district court issued it after an adversarial hearing, which challenged the basis. The hearing came after the parties filed extensive written materials. The plaintiffs moved for a TRO, the defense filed an opposition, and then there was a reply. Moreover, the court scheduled a hearing for June 20th to determine whether it should issue an injunction. The TRO does not automatically expire on that date, so it could still be enforced for more than 14 days. Yes, it can be enforced forever because there was no end date. It also has the practical effect of an injunction. It enjoined defendants from deploying members of the National Guard and directed return of control. Trump determined that he cannot ensure protection without using the National Guard. If the defendants are not allowed to appeal the TRO, they would effectively be foreclosed from pursuing further relief because the National Guard couldn't be used. And they say on these facts, we are doing the injunction. Issues of appellate jurisdiction do not affect the likelihood of the defendant's success on their appeal from the TRO. So now you talk about the factors staying court decisions. Now remember, seeking a stay is not easy. You have to show things like whether you've made a strong showing you're likely to succeed. You know, will you be irreparably injured absent the stay? Probably, yes. Whether issuance of the stay will substantially injure the other parties? No, because they're in no different position than they were. And where the public interest lies. So the first two factors are the most critical. And I would agree, the first two factors are the most critical. They're the paramount factors to consider here. They are the most paramount factors to consider. And those first two factors, again, guys, are where did I go? The likelihood to succeed and whether or not you'll be irreparably injured. All right. So likelihood of success. In determining whether or not the showing, we only address the district court resolved in granting the TRO. The defendants argue the court erred. The defendants also argue the court erred in concluding the plaintiffs were likely to succeed. The parties agree that the 10th Amendment claim rises and falls with the ultra vires claim. Because if it's not outside his authority, then he's allowed to do it, and the 10th Amendment has to take a back seat here. In opposing the stay, plaintiffs do not press their claims based on posse comitatus or the APA. And they say, consequently, the parties' disputes about how forces are being deployed are not before us. So they talk about the president's authority under 12406. They start with political questions. They argue that this is a political question, and therefore, if it's a political question, courts cannot intervene. They say, nope, that's bullshit. So, in general, the court has a responsibility to decide cases, even those it would gladly avoid. And there's a narrow exception known as the political question doctrine, and that's under Baker v. Carr. If the courts cannot get involved, it's a political question, they have to stay out of it. So, the political question doctrine is grounded in the constitutional separation of powers. It's been limited to constitutional cases. And even through 2010, Justice Kavanaugh wrote, it's only in cases involving violations of the Constitution and has not been available in statutory cases. Applying in cases would systematically favor the president over Congress by ignoring the limitations the latter placed on the former's authority, threatening the very separation of powers the doctrine is meant to protect. They say, thus, to determine whether it is precluded, we must first determine whether the authority to federalize the National Guard is statutory or constitutional. They included statutory, and it's true. Under Title 10 of the United States Code, that's a statute, so it's a statutory power. Easy analysis. I agree with that. It's an easy analysis. David says, it's been a while since we had a good president. You guys are something else. They say the Constitution provides a commander-in-chief of the militia is the commander-in-chief of the militia of the several states when called into the actual service of the United States. But here's the thing. You might say, well, that makes him the commander-in-chief, so it's a political question. It's not, though. The Constitution authorizes Congress, not the president, to determine when and how the militia can be called in the actual service. So notice, when the militia is called up, he is the commander-in-chief, and that's an Article 2 thing. But to get to that point, he has to have a statute that enables him. So calling them up is statutory. And that's the difference here, chat. And that's why they do this. So they say, pursuant to the militia clauses, Congress has the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repeal invasions, as well as to provide organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. Congress delegated some of its power to call forth the militia by statute, which is under Title 10. which authorizes the president to call into federal service members and units of the National Guard of any state under specified exigent circumstances. Both parties agree that calling the members of the National Guard into federal service is the legal equivalent of calling forth the militia. And because the militias don't exist anymore, the militias went away in 1903 with the National Guard acts that established National Guards in every state. The militia was the entity that the governor had at his disposal prior. So the governor would have called up the militia, the state militia, to handle riots and insurrections and lawlessness in his state. That's how he would have addressed it before there was a National Guard. Like I said, Chet, up until the 20th century, there were state militias. So, yes, the kingism, yes. Militias nowadays are FBI and ATF ops. Different militias now. Different militias. Yes, Chet, if you go to a militia meeting and you're not the Fed, everybody else there is a Fed. Okay? So, Robert Lawrence gifting 5 subs. Thank you, Robert. Got some late afternoon support going here, chat. Thank you so much. Nick Kreuzer for $5 says, "Oh man, an early show. It's like 3 p.m. in the morning, dudes." Thanks, Nick. Thank you guys for your support. I appreciate it. And Bella says, "Does Florida have a state guard?" Yes. Florida has a state guard. Texas has a state guard. Those are entirely independent organizations. You join those are entirely at the behest and beck and call of your governor. So in Texas, there's a Texas State Guard. It's entirely under the authority of Governor Paxton. They operate without any military funding from the government. They don't really have the military structure in the same sense. Like, you can quit at any time. You're not like, it's just like a gun club, though, in the sense of you don't have those same authorities and jurisdictions. Governor Paxton, Governor Abbott. Governor Abbott. I was thinking Ken Paxton, the Attorney General. But these state guards are generally not well funded. They don't have the, they're not really helpful for things except like disaster response. So yes, there are state guards, but they don't have any really power or authority. For the first half hour, I thought this was a clip video, not live. Oh, I'm sorry, Katie. So, but that's the state guards are very different from the National Guard. And most people, I will say, people know of like the Texas State Guard. They were kind of seen of as a joke. So, I mean, they exist, but nobody takes them seriously. There's a California State Guard, yes. And in Ohio, there's the Ohio Naval Militia. And there was technically for a long time an Ohio Volunteer Militia, but that really doesn't exist anymore. So, when you think of like these state guards and whatnot, they're basically quasi recognized militias. Kimmy says, "My son in the National Guard was picked up by a militia member when his truck broke down. That guy went on his way to help him out." I'm not saying they're not a real thing. I'm not saying they're not real, but I'm just saying they're not. It's not like they have access to like the funding the DoD has. Like, anything you want to equip them with, weapons and equipment, has to come from state budgets, the federal government. So, for example, in Ohio, we have, if there was a National Guard unit that used tanks, those tanks are supplied by the federal government. The state of Ohio didn't buy those tanks. Just like in Columbus, there's a aerial refueling wing of the Ohio Air National Guard. The state of Ohio does not own KC-135 tankers. The federal government and the United States Air Force own KC-135 tankers that are assigned to the National Guard. So it's a little different there. Dolly, state guards, think of them just as like the state's own militia, and it can make it as important and equipped as it wants to, but it's entirely on their own to do that. So, but if you really want to look at it, check out your state guards. You can Google them and you can see they're not at all like a National Guard unit. Moving on, at various points in the litigation, the defendants have referred to the president's inherent constitutional authority. But defendants represented the district court, they're not arguing that Trump exercised some other independent Article 2 authority. Rather, the only authority the president invoked was this particular statute, which is 12406. The defendants thus do not argue the president's inherent authority, whatever its scope, would allow him to take measures incompatible with the express or implied will of Congress. And we're talking about Youngstown Sheet and Tube. It's that this is a critical case in Article 2 discussions. Justice Jackson wrote a famous concurrence, and that was regarding Truman federalizing and sending the army to go run a steel mill in the middle of a strike during the height of the Korean War. And it was in Youngstown, Ohio, because it was that big a deal. They needed steel production. The source of the president's power to federalize the Guard is statutory, not constitutional. Therefore, the political question doctrine does not bar judicial review. And that's also the point. If it's a political question, the court has the right to decide whether or not it's a political question. You can't just say it's a political question, end of story. The Supreme Court or the courts can look at it and go, is it? And they go, I guess it is. Or they'd say, I guess it's not. So the question they must answer is, to what extent has Congress committed the challenge decision to the president's discretion? The question is a matter of statutory interpretation. And they cite Trump versus JGG. These are the immigration cases, explaining the questions of interpretations of statutes fall within our purview. Now, remember, that regarded the Alien Enemies Act. And while the Alien Enemies Act, the president has the authority to designate people enemy aliens, courts have the right to decide what the hell, whether or not he had the right to do that, and whether it was just and proper. And they do go back to what the trial court cited in Marbury versus Madison. It's the province and duty of a court to say what the law is. And this includes determining limits of statutory grants of authority. And they say, as with any question, the analysis begins with the plain language. And interpretation of a word depends on reading the whole text. You consider the purpose and context of the statute, and you consult any precedents or authorities that inform the analysis. And here's the statute. Title 10, 12406 says, whenever the United States or any of the commonwealths, remember, there are states and commonwealths, or possessions, meaning like Guam, the Mariana Islands, Puerto Rico, are invaded or in danger of invasion by a foreign nation, there's a rebellion or danger of rebellion against the authority of the U.S. government, or number 3, the president is unable with regular forces to execute the laws of the United States. Well, if any of those 3 happen, remember, any one of 3. One of 3. You don't need all 3, you just need one of 3. The president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders shall be issued through the governors of the states, or in the case of District of Columbia, through the commanding general of the National Guard of the District of Columbia. And remember, that's because the District of Columbia does not have a governor. So the District of Columbia is governed by Congress. And since they don't have a governor, well, who's in charge of the National Guard regardless? The commanding general, which would be their, and because it's not a state, he's not an adjutant, but would technically be the adjutant general of the DC National Guard. The defendants conclude this precludes review. They rely on a case, Dalton v. Specter, saying that whenever a statute commits decision-making to the president, judicial review is not available. And they say in Dalton, the act regarded the closure of military bases, and it authorized unfettered discretion by the president to approve or disapprove the package of base closures. Now, if you notice what this is all about, this is 1994. This is when you heard about BRAC, base realignment and closure. It's the end of the Cold War. So we had to close down all these military bases. We didn't need them anymore. We won the Cold War. So, and they were proposed by an independent commission. So, and once again here, chat, without even knowing they said it, it said BRAC. Let's say the president shall transmit to the Constitution and the Congress a report containing the president's approval or disapproval of the commission's recommendations. The act by its terms did not circumscribe the president's discretion to approve or disapprove the commission's report. The court concluded the decision was not reviewable for abuse of discretion. They said, unlike Dalton, the statute here enumerates 3 predicate conditions for the decision to call up the National Guard. And as the district court said, the text does not make the president the sole judge of whether one or more conditions exist. They say, thus they agree that it is not prohibited from being assessed judicially. And they say, however, that leaves a question of whether we owe that determination deference, and if so, how much? They say, again, it's a question of statutory interpretation. If we consider the text of 12406 alone, we might conclude the president's determination is subject to review like certain other factual findings that are preconditions for executive action under a statute. And notice they cite another case, Jane Doe #1 versus Trump, and I don't know what that one's about. They say, but we are not willing to write on a blank slate. We can't. We have case law behind us. The history of Congress authority, statutory delegations of its calling forth power, and of a line of cases beginning with Martin v. Mott. And that is regarding a guy who was called up to federal service. He was a soldier and he challenged it. Interpreting those delegations, it strongly suggests that review of the determinations is especially deferential because you're getting into Article 2 powers. He is now the commander in chief of the army. And because of that, when he decides to call them up, you're now getting into, you're getting from a statutory power very quickly into constitutional powers. So Congress delegated its power calling forth the president under the Militia Act of 1792. They renewed it in the Militia Act of 1795, and this is a precursor to the Militia Act of 1903. And unlike 12406, the first acts contained a predicate invasion condition. And notice they point out here that, when the United States shall be invaded or is in imminent danger, shall be lawful for the president to call forth such members of the militia as he may judge necessary to repel. They compare that today to 12406, saying whenever the United States is invaded or is in danger of invasion, the president may call into federal service members and units of the National Guard of any state in such numbers as he calls necessary to repel. And they say the Supreme Court interpreted the Militia Act in Martin, which arose out of president's decisions to call the New York militia into federal service during the War of 1812. Jacob Mott, a New York militiaman, refused to turn up for service. He was court-martialed and fined, and the state seized his property to satisfy the debt. Mott then brought an action for replevin, returning of property, in state court arguing the seizure was illegal because the order federalizing the militia was invalid. SCOTUS rejected the argument. SCOTUS began by explaining the Constitution gave the calling forth power to Congress, but Congress confided that power to president when the exigency of an invasion has arisen. The court first recognized that the delegated power was in its terms a limited power, confined to cases of invasion or imminent danger of invasion. And then they say the court says, if it be a limited power, by whom is the exigency to be judged of and decided? Is the president the sole and exclusive judge of whether it has arisen? Or is it to be considered as an open question upon which every officer to whom the orders of the president are addressed may decide for himself, and equally open to be contested by every militiaman who shall refuse to obey the orders of the president? Now they're pointing out here who gets to decide whether or not it's a serious problem. Are we going to decide whether it's a serious problem? They're going to say no, because we're not going to get into the president and how he exercises that power like that. Because if we're not going to let Private Snuffy Private Mott do it. We're not going to do it. Stop it and Wormy Shanahan. What did you say, Jim? I didn't see what you said, so you're gonna have to suffer more. Suffer. Been there, done that, says the Nasty Girls. Yes, that is the nickname for the National Guard. So the court answered the question by stating the authority to decide the exigency has arisen belongs exclusively to the president, and that decision is conclusive upon all other persons. In reaching that conclusion, the court relied in part on the nature of a foreign invasion and the need for military subordinates to follow orders. Once again, we're getting the commander-in-chief territory. Your boss, the commander-in-chief, made a decision. In particular, because the power is exercised upon sudden emergencies, there may be vital to the existence of the Union. The court reasoned every delay and every obstacle to an efficient and immediate compliance necessarily tends to jeopardize public interest. And they say the 1795 Act supported its conclusions drawn from the nature of the delegated power. The court followed the sound rule of construction and said whenever a statute gives discretionary power to any person to be exercised by him upon his own opinion of certain facts, the statute constitutes him the sole and exclusive judge of the existence of those facts. And the court explained that the power to delegate under the Militia Act is susceptible of abuse, therefore the remedy is political. In addition to the high qualities which the executive must be presumed to possess of public virtue, an honest devotion to public interest. Okay, well, that's so funny. That's so funny because no politicians have that, not even Trump. The frequency of elections and the watchfulness of representatives carry with them all the checks which can be useful to guard against usurpation or unwanted tyranny. Well, what does that mean? You have the power to impeach. You can remove. You can pass laws. As a representative, you can do a lot of things. We have an election every 4 years. So we have safeguards. There are checks and balances. The plaintiffs do point out, though, that the Martin Court addressed circumstances that aren't present here, particularly the nature of a foreign invasion and concerns about militiamen disobeying orders. And that hasn't happened here. And they say, still for the following reasons, we conclude that Martin and his progeny, we must give a great level of deference to the president's determination that a condition exists. And they say, and why? Because him to do this, Congress has given them authority. And once he decides it, well, now you have, once again, you have run-ins of power. Things start to cross. Take it good says he really went to the Supreme Court over not showing up to work. They took his property. They seized his farm and said, we're taking your land to satisfy the debt from your court martial. So yeah, I don't blame him. I don't blame him for going forward. That's kind of a rough sentence. Remember, it's the War of 1812. So all kinds of stuff happened. And the War of 1812 was a unique situation for the government. And still, the War of 1812 is one of the coolest flags ever. If you guys have never heard of this before, the Veterans Exempt Company. It was a company of Civil War veteran or Revolutionary War veterans. And they showed up and fought in the War of 1812. And they had the gnarliest flag ever as far as battle flags were ever. And it's funny because they were New York militia volunteers. They were exempt because of their age and injuries. And they guarded the home front in New York while the other soldiers fought. And they have the coolest flag if you guys have never seen it before. This is the Veterans Exempt flag. And like I said, it is the gnarliest thing ever. This is their flag. If you guys have never seen it, it's black and white, and it's got the Gadsden flag. It says "Don't tread on me," and then it's got a skull and crossbones saying "Thy will be done." This is some stuff out of Warhammer. You guys want to talk about The God Emperors are part worm. Yes, well, there you go. But yes, this is some Warhammer stuff right here. Yes, called the Veterans Exempt Company of the New York Militia. That looks like some Gears shit, yeah. Well, it looks like a 1997 GeoCities website. Well, it was a flag made in 1812. Give them a break. But yeah, these guys were badass. They fought the Battle of Plattsburgh, and they fought the British. They fought the British because they were the guys holding down the front. They were a real thing. They were a real thing. So they also fought. It kept the British out of northern New York, and it kept Lake Champlain in American hands. So that skull is smiling. Yeah. Has no one used this before recently? I don't think so. But it is still one of the gnarliest things ever. It's still one of the gnarliest things ever, and it's neat history. It's neat history. So, and they say much of the court's reasoning in Martin appears equally applicable, regardless of the facts here. They say the power to command the militia in times of insurrection and invasion are natural incidents to duties of superintending the common defense and of watching over the internal peace of the Confederacy. Now, notice this here, they're quoting Federalist 29 by Alexander Hamilton. Remember, the Federalist Papers were Alexander Hamilton and James Madison, trying to sell the populace on supporting the Constitution when it was being ratified. And they say, second, if Congress had disagreed with the Martin Court's interpretation, it could have amended the statute to provide for greater judicial review of the existence of a predicate condition. Congress did not do so, and since then, Congress has modified the statutory delegations in various ways, but the text of 12406 is in material respects the same as quoted in 1795. And it pretty much is. Remember, it changes militia and National Guard, but for the most part, it is the same language in the same material respects, the same thing. They say, we presume that Congress is aware of pre-existing judicial interpretations of statutory language. It replicates in later statutes, and that it seeks to import those interpretations into a new statute. Meaning, Congress is aware of this, and they intend to do this because this is what they want. If Congress didn't want this to happen, hold on, chat. All right, 2.0 turn on the air. Just making sure. And that if Congress didn't want to do this, they could have said, hey, explicitly excluding that. Or they would have worded it in a way that judicial language doesn't follow along. But they didn't. So there's a presumption they're cool with this. They're cool with this. Mike says, does Confederacy now pertain to the entire U.S.? Well, at the time, it would have been. It would have been the entire United States because Alexander Hamilton called it a confederacy. So. Noel's autistic about flags? I didn't realize. Oh, not like me. And they say, of course, Congress still has the prerogative to change the delegation of the calling forth power and the nature of judicial review of any exercise of that statutory authority. And it says, third, the Supreme Court has not understood Martin to be a narrow decision, addressing only the military chain of command. They talk about other cases, Luther v. Borden. The Supreme Court evaluated an action for trespass that turned on which of two factions was the legitimate government of Rhode Island. During the dispute, President Tyler concluded there was enough unrest to invoke the promise of federal protection against domestic violence in the guarantee clause. The president's ability to call forth the militia to offer that protection came from the Militia Act, which permitted him to do so in case of an insurrection against any state, the government there or state government thereof. And relying on Martin, the court explained the 1795 Act gave the power of deciding the exigency to the president. And that part makes it clear. Well, what is an insurrection? Well, the president gets to decide what the insurrection is. And you go from there. Say the court made clear the president's authority was preclusive. And this is after the president has acted and called out the militia, is the Circuit Court of the United States authorized to inquire whether his decision was right? If the power extends so far, the guarantee contained in the Constitution is a guarantee of anarchy and not of order. And that's true. Once again, you're now getting into not only the calling forth, but at that point, he's the commander-in-chief. The view of Martin has remained settled understanding of the Supreme Court among legal scholars. And it goes to Zidovsky, where even Sotomayor concurring, citing Martin for the proposition that courts are practically ill-suited to intervening in exigent disputes, necessitating the unusual need for attributing finality to the action of political departments. There's got to be a finality to it. So they also cite here Vladeck. That's Steve Vladeck. He's a constitutional scholar out at Georgetown. He's on Twitter if you want to follow along him. A little left, but yeah. They say, per the mock court, the Militia Act granted broad power to the executive to determine for himself when circumstances necessitated the calling forth of the militia. And such a determination was not subject to judicial review. They also talk, there's a couple different legal, this is a law journal, the Journal of National Security and Law and Policy. And from here, they cite that cases involving the court held that the courts could not review the president's determination that it existed. And they say, given the nature of the statutes, Martin requires the president's determination that an exigency exists to be given significant deference. And they say, fourth, we recognize that Martin concerned a question that directly implicated foreign policy. Well, that's different. They said, well, this case implicates the domestic use of military force. And that is a general rule. We afford the president greater latitude in the former context. Yeah. You know, for example, when you're doing stuff foreignly, yeah, you're pretty much going to be allowed to do it. And they say power is more circumscribed when he addresses a purely domestic economic issue versus a foreign one. And they say, however, 1206 is not limited to the domestic use of military force. Rather, the statute permits the president to federalize the guard whenever the states are invaded or in danger of invasion. And they say, we see no reason Congress would have intended for the president to receive significant deference when he invokes the first precondition, but not when he invokes the second two. And that's true. If they wanted to do that and separate them out, they could have made them separate to show separate things. But remember, it's just like how we normally interpret things as regular people. When you group things together, you generally presume the rules apply to the group. The conditions apply to a group. How you use it applies to the group as a whole. No, I've never heard Null talk about flags. I haven't really heard him talk about anime flags, so I don't really care. No, I've not heard Null talk about flags, really. I've heard Null talk a lot. They say, moreover, California's contention is undercut by Luther, which heavily relies on Martin when evaluating the deference. California emphasizes that Martin is nearly 200 years old. Marbury versus Madison is very old, too. And that is in some tension with the more recent decisions about the reviewability of executive determinations, like the Alien Enemies Act, and even determinations about questions such as the existence of an invasion. Seeing JGG, remember the Alien Enemies Act. So, and they talk about Ludicky, and that goes back to JGG. So what do they say here? But Martin's continuing viability is not for us to decide. The Supreme Court has admonished that if a precedent of this court has direct application, yet appears to rest on reasons of rejected in other lines of decisions, the Court of Appeals should follow the case which directly controls. leaving it to the Supreme Court the prerogative of overruling its own decisions. So that's where it's not for the appeals court to say, well, the Supreme Court overruled X, Y, and Z, therefore I'm going to overrule A, B, and C. No, you follow X, Y, and Z, and the Supreme Court will overturn it if it decides to. It is their decision. They said Martin does not compel us to accept the government's position that he could federalize the National Guard based on no evidence whatsoever, and that courts would be unable to review the decision that was obviously absurd or made in bad faith. In Martin, the court addressed the argument the power confided to the president is a limited power that can be exercised only in the cases pointed out by the statute. And the court explained that when the president exercises an authority confided to him, the presumption is that is exercised in pursuance of the law. And they say public officers are presumed to act in obedience to their duty only until the contrary is shown. So yes, they're presumed to act in good faith until you can't show they're acting in good faith. And they say, moreover, the court has observed the nature of the power also necessarily implies there is a permitted range of honest judgment as to the measures taken in meeting force with force, in suppressing violence and restoring order. And that such measures conceived in good faith in the face of the emergency and directly related to the quelling of disorder or the prevention of its continuance fall within the discretion of the executive in exercising of his authority to maintain peace. So we already presume there's a good faith presumption. And then when that presumption over decisions is an honest range of outcomes, as long as it's in those, and those outcomes are conceived in good faith, we're not going to get in the way of it. We are going to agree to do it that way. We are going to agree to do it that way. Parallax says, am I still planning on covering Russell Greer tonight? No. Runkle is interviewing Alessi and Yannetti. I want to watch that. That's pretty fucking big. I definitely want to see it. I definitely want to watch it. So no Russell Greer tonight. No Russell Greer tonight. Sorry. Noel's a flag it. How do you not know this? I guess I just never noticed. I never noticed. So they point out that they say consistent with Martin, courts may at least review the president's determination to ensure it reflects a colorable assessment of the facts and law within a range of honest judgment. So remember, they can just say, look, is it reasonable? Yes. And remember, reasonable is a wide deferential area. Reasonable could be a lot of things. As long as it's just not retarded, it's good to go. And they say at the preliminary stage, we need not further specify the precise standard that governs our review. And they say with those principles in mind, we consider whether the president exceeded his limits. And they start with 12-4063. He is unable with regular forces to execute the laws of the United States. And they say because that provision is sufficient to allow us to conclude that the defendants are likely to prevail, we do not reach the other condition invoked by the president concerning rebellion. Because he met one of them, we don't have to prove them both. The district court interpreted this as recording total or near total interference. They say, nor does the statute allow for the federalizing of the National Guard when the president faces some risk in executing the laws. They require him to be unable to execute, and that did not happen here. And the court says, wait, and they agree with Trump. This can't plausibly be read to mean that so long as some amount of execution remains possible, the statute cannot be invoked, regardless of how much execution of the laws remains thwarted or how much personal danger is being faced by federal officials. So long as any quantum of federal enforcement can be accomplished in the face of mob violence, the president would be able to call up the guard to respond. And that's true. Well, what could the president do? Oh, well, they could go out and arrest like one illegal alien. Okay, well, there's no insurrection. There's no inability. It's like, wait, they're shooting at ICE guys. Well, can they still arrest somebody? Yeah, well, there you go. Go arrest them. And they say 12406 does not have as a prerequisite that the president be completely precluded from executing the laws in order to call up the National Guard. Nor does it suggest that activation is inappropriate so long as any continued execution is feasible. They say, on the other hand, we do not think that minimal interference by itself is enough to justify invoking 12406(3). The statutory context confirms that. Subsections 1 and 2 discuss unusual and extreme exigencies, invasions, and rebellions that threaten the normal operations of civil government. If we were to adopt the government's reading of subsection 3, meaning any inconvenience, it would swallow up sections 1 and 2 because the ordinary would swallow up the extraordinary. And because invasions or rebellions render the president unable to exercise federal laws, it makes sense. They say Congress would not go to the trouble of spelling out a list of terms if a neighboring term swallowed it up. Yes. Why would you list all of this out if you could merely just point to one that says, this always applies? You would not list the other things because they wouldn't be necessary if the other thing always applied. So moving on from there, you guys. Moving on from there. Under a highly deferential standard review, the defendants have presented the facts to allow us to conclude the president had a colorable basis for invoking 12406. They presented evidence of the interference in the ability of federal officers to execute laws leading up to the federalization. There is evidence that the day before, protesters threw objects at ICE vehicles, that a law enforcement operation pinned down several officers defending federal property, that the dumpsters were being used as battering rams in an attempt to breach the parking garage of a federal building. And their own submission states that some protesters threw Molotov cocktails and vandalized property. Those activities significantly impeded the ability of federal officers to execute the laws. And they say, affording appropriate deference to the determination, we conclude he likely acted with as an authority in federalizing the National Guard under Title 10. And now they get to the procedural requirement. This is about issuing it to the governor. So, hey, we complied. We complied because the president called Governor Newsome about the situation in Los Angeles. And then we sent the memorandum to the adjutant general, along with the memorandum that contained through the governor of California in its title. And the adjutant then forwarded them both on to Gavin Newsome. Trump also argues that even if they were cited as technical errors, any procedural error can't justify the injunction because he's not legally required to obtain the consent of the governor or consult with him before calling the National Guard into federal service. And they say likely you met the procedural requirements because the issue is ordered through an agent of the governor in the governor's name. And under California law, the adjutant general is chief of staff to the governor, subordinate only to the governor as the commander of all state military forces. So the adjutant general's duties include issuing all orders in the name of the governor. And they say the plaintiffs do not dispute that the adjutant general received the memoranda from the Secretary of Defense. He relinquished command to the federal military accordingly and forwarded the memorandum on to Governor Newsome. And although Newsome did not personally issue the order of relinquishing command, 12406 requires that the president's order be issued through the governor, not directly by the governor. Nothing prevents the state from delegating to a subordinate, such as the adjutant general, the governor's authority to issue orders. Even if there was a strict adherence to a process that you had to do, the failure to issue the order directly through the governor does not limit your otherwise authority to call up the guard. And they say, first, the governors have no veto power. The omission of an express consent requirement is telling, as Congress provided governors with veto power in other parts of section of Title 10. And there are other parts of Title 10 that require the governors to be involved. And they say, however, a member of the Army National Guard of the United States or the Air National Guard may not be ordered active duty under 12301 without the consent of the governor or appropriate authority of the state concerned. But notice we're in 12301, not 12406, so different statute. And they say, similarly, the argument the text requires the governor to be consulted is not supported by the language. Rather, the decision to activate the guard is textually committed to the president alone. They say, even with the requirement the orders be issued through the governor, that provision does not grant the governor any consulting role. It simply delineates procedural mechanisms through which the president's orders are issued. And they say, second, the purpose and context suggests that the statute does not affect the president's authority to federalize the National Guard. As discussed, it delegates to the president part of Congress's authority to call forth the militia. The president's power under 12406 is similar to his authority under the statute analyzed in Martin. And they say, in that context, we think it unlikely that Congress would have enacted a procedural requirement giving the governor effective veto power over the president's otherwise lawful orders. And they say, in any event, the defendants failed to comply with the statute's procedural requirement, such a failure would not justify injunctive relief. And assuming arguendo, meaning for the sake of argument, the plaintiffs were likely to prevail in their claim of violating the procedures, the proper remedy would be injunctive relief tailored to the failure through the governor. And not just an injunction prohibiting the president from exercising his lawful authority to call the guard. And they say at most, such tailored relief would be an injunction directing the president to send the relevant document to the governor. And that's what would happen. They would say, look, Trump, send him the letter. Okay, I've complied. Now we're done. So. Clyde is still busy helping 2.0. I think so. Hold on, let me see. Mr. Clyde! Come here, Clyde. Mr. Clyde. What? Okay. Guys, sorry, Clyde is done for the day. He's having a peen break. So Clyde's chewing on a brand new peen. Sorry. Yes. Buy Clyde. Yes, buy Clyde coin. Thank you, Robin. Scott. Thank you, Scott. Big support for Clyde out there in chat. Blue Varo gifted 10 subs. Thank you, Blue. Base Shaman for $5. Good to see you, man. It says Trump won because there are judges trying to avoid a trail with an injunction which will last his entire term. When he leaves, it would be moot. I can understand the theory there. So, I mean, also, if you guys are talking about Noel sounds like he's like that CGP gray guy. Where like, this flag's too cluttered. It's like, a lot of states have shitty flags because they have their crest on them, but it is what it is. And they should stay that way. They say, in sum, the defendants likely complied because the adjutant general exercises delegated authority and issued the order in the governor's name. Even if they failed to comply, Governor Newsom had no power to veto or countermand the president's order. Thus, they're likely to prevail on the claim because the procedural violations had no effect on Trump's authority or 12406. So there you go. So now the other stay factors, whether the applicant is irreparably injured, whether the issuance of the stay will substantially injure other parties, and where the public interest lies. So remember, guys, we spent how many pages? 30-some pages going through part one. Part one's usually the biggest one. Can you win? And we have 4 pages. We have 3 pages left, and that tells you how important these are to the Ninth Circuit right now. When they say the last 2 factors, remember, there's 4 factors. The injury of the parties and the public interest, the equities, Those merge. So when the government's involved, you go from 4 to 3. We talked about that before, you guys. We talked about that before. So the irreparable harm and the public interest weigh in favor of Trump, who have an uncontested interest in the protection of federal agents and property and the faithful execution of the law. And the undisputed facts demonstrate that before the deployment of the National Guard, that officers were pinned down and that concrete chunks were thrown at the officers. Protesters also damaged the federal building that caused the closure of at least one federal building. And a federal van was attacked by protesters who smashed in the windows. The interest in preventing this incident is significant. It is very significant. Plaintiffs argue the public interest issues against issuing a stay because the National Guard would upset the constitutional balance of power between the federal and state government. They said, while we recognize that significant interests are implicated here, their arguments are, in essence, a merits argument that we have already resolved. The Constitution assigns the power to call forth the militia to Congress, and Congress delegated portions of that power to the president. And they say, as discussed here, under the facts before us, we disagree the defendants have clearly exceeded the scope of their authority. So they are acting in accordance with the constitutional federal and state balance. Expressing concern about what they describe as a nearly limitless conception, they are in this case the first time the president has invoked 1206 to order troops to patrol the streets of an American city in support of routine civil law enforcement activities, while civil law enforcement officials at the local and state level all remain available for work. They say, we emphasize that our decision addresses only the facts before us. And although we hold the president likely as authority to authorize the National Guard, nothing in our decision addresses the nature of activities in which the Guard may engage. So they're saying he likely has the power to call them up, but what's he doing with them? Well, that's another issue for another day. They say before the district court, plaintiffs argued that certain use of the National Guard would violate the Posse Comitatus Act. The district court found the claim to be premature and plaintiffs have not renewed it. We express no opinion on it because it hasn't been arisen. Nobody brought it up. So you can't comment on it. And that's fair. Till something happens, we won't talk about it. They also urge the interest of the continued presence risks worsening, not improving tensions on the ground. These concerns are counterbalanced by the undisputed fact that federal property is damaged and federal employees have been injured. And the evidence presented at the TRO hearing shows the federalized National Guard members have only been engaged in protecting federal people and their property. And they say with respect to the issues here, the plaintiff's concerns have more bearing on the question of whether the president should have federalized the National Guard, not whether he had the authority to do so. Remember, their arguments are moral ones. Should you do it, not can you do it? You know, you spend so much time worrying about whether or not you can do it instead of worrying about whether you should do it. That's not an issue for a court to handle. And they say, we also don't know whether protests will continue to grow because of the National Guard. You know, you can't rely on the predictable effect of government action on decisions of third parties. Rather, they can only speculate about the decisions. They say, we do not know what emergencies, we do not know what may occur in California while the Guard is deployed. Accordingly, the state factors weigh in favor of the defendants. So for the reasons above, we grant the motion asking for a stay on appeal. So that is how we get to that point. Hold on, chat. So there you go, guys. It's pretty much straightforward. You guys may not like this, and this may be unsavory and unsatisfying, but he is allowed to do it very likely. He's allowed to very likely do it. Now, from here, though, because today's the 20th, there was a preliminary injunction hearing in front of Judge Breyer. So it stayed for now, but they still had a preliminary injunction hearing. And Margot Cleveland is over at the Federalist, and she is, if you guys have never seen before, the Federalist, she's been covering all the Trump stuff very well. And Breyer says the facts on the ground and changes would be relevant to the injunction. And she says, watch from the sides that the Ninth Circuit slapdown by framing changes on the ground as so substantial, no matter how much deference he gets, he can't federalize the troops. So the hearing is supposed to start at 10 Pacific, which means 1 o'clock our time. It hadn't started yet. And then she goes on, starting momentarily, the crowd is showing up. You could have accessed it live. The hearing started and the attorneys provided appearances. And the judge said, everyone had a late night. Yes, reading the Ninth Circuit, slapping you down. Slapping your ass down. Then what happened from here? Let me review where we are as that informs where we go. The court granted the TRO and the Ninth administratively stayed it and then stayed pending appeal. In order, the Ninth Circuit is effectively a preliminary injunction, thus it has appellate jurisdiction. I'm a district court. My decisions are reviewed by the Ninth Circuit. Just as you can't ignore my decisions, I can't ignore the Ninth Circuit. Is precisely how to do that. Nobody challenged posse comitatus. The plaintiffs argued certain points violated it. The Ninth Circuit said the disputes are not before us. It is not clear to me the Ninth Circuit stayed Vestas Court the power to grant such modified by posse comitatus. The district court has authority to modify a TRO and an injunction, and they can. The court who issues an injunction can modify it. He's asking for a briefing on whether to modify the injunction under posse comitatus by June 23rd, which is Monday. I missed that it was, and he says, depending on what you say, I'll decide what to do next. And yes, she's right. Holy crap, he's going to use posse comitatus. So they go on to address issues here. Say the judge, now this has been converted to a preliminary injunction, so I don't have jurisdiction over PIs. The Ninth Circuit does. You're asking what is the duration of the National Guard. I understood 60 days. It's a 60-day time limit, but that can change at the discretion of the Secretary of Defense. And they're saying because it's renewable, we believe another issue is when it should end. We want the court to consider the duration of the order. And he says you can address that in your briefing. He says, sorry to ruin your weekends, but suffer. And her thought is, Judge Breyer is going to hold Trump's violating posse comitatus, but wants to pretend he's being open-minded, so is asking parties a brief whether he has jurisdiction. So the judge is going to sidestep all of the court orders at this point and do what he won't. He's going to be like, I'm a federal judge. I do what I want. So we'll see how that turns out for him, because this is just horseshit, but he is doing it. He's going to do it, chat. He's going to do it. So. Not to do anything, so. He's going to do it like that. So just, yeah. So there you go. Is the Supreme Court next court up from him? No. He is District Court, Ninth Circuit, Supreme Court. So, yeah, we're going to go down the posse comitatus road, it looks like. Mike says, is the president the only one who could call upon the Insurrection Act? At the federal level, yes, but the governors have the ability to declare martial law. They can call up the National Guard and have them out on streets. They can do a lot of things. They don't have federal authority. They have state authority, and I'm sure that every state has some level of an insurrection or rebellion act on its books as well. So could a governor do it? Yes. Mike is saying there does specify some foreign nation. Could someone claim there isn't a specific nation in this case? Yeah, but the courts aren't going to go along with that going from the JGG case. They're not buying it. They're not buying it. David from Making Law Simple. Good to see you, David. He says this is going to lead to a constitutional crisis. 100% it is going to. I hope where the state's authority and the federal government finally come to blows for the first time since 1860. Oh, this is going to be a showdown. This is a federalism showdown. This is a showdown of separation of powers. I told you guys, these people are pushing to find the limits of Article 2. And we will find them, or at least get some basic ideas. So, it's a thing. It is a thing that's happening. I promise you, it's a thing that's happening. Is the posse on Broadway? No. Will the same appeals panel get his posse comitatus order? I don't think so. Possibly. But even then, I think even with the Ninth Circuit, even they realize, like, this shit's a little out of hand, guys. I think the Ninth Circuit's, because they're going to run into inconsistent panels. But notice, Gavin Newsome didn't immediately go cry for an en banc hearing, which he would have gotten, because he knows the Ninth Circuit's going to rule against him, and he doesn't want to set bad case law against himself. So that's why he's not doing it. So, just something to think about. So that is where we are. Sean Rutledge says this is audition to the Supreme Court in 2028 should the Dems win. You mean for Breyer? No, they have other people. If you go look around, there's actually, maybe I'll do this one day. I'll bring Kurt in and we'll talk about it. The Federalist always kind of has their list of people they want to put on the court. We should go through who the left wants to put on the court, because it's not him. He's 83 years old. He's not going on the Supreme Court. Send the 81st and 182nd, 101st to make them jump in. Well, technically, if you ask the 82nd, the 101st doesn't jump. They're air assault, not airborne anymore. Darcy says Rob Bonta was on the Attorney General of California, who said they're going to keep fighting. Yes, they would. But that's yeah. Yes, from here on says Banda de Hermanos. Yes. Yes, the fortunate sun switch got activated. Oh, actually, you know what, chat? Maybe you can help me. You guys know what with the recorder, when people have like meme videos and there's like the recorder things playing. What's the song go? It's like bum 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 do 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 do. I was trying to. I don't know what that is, and I can't get it out of my head. Stabby says, if you want to see Sean with sand in his posse, watch him trying to assemble a train model. Yes. Andros is up from my weed coma. Did I miss the whole live? Pretty much. The only recorder song you know is the Titanic one. No, it's not the no, it's not that one. It's not from Mrs. Robinson. I'm trying to think. I'm trying to figure out the rest of it. So it's Undertale. Okay. Sean says, thanks for reading in the comments, by the way. Oh, you're welcome, dude. I love good questions and good comments. It also helps me, there's only 300 people here, not 3,000. So all right. Well, guys, I'm going to let this end here for now. We're going to go on with Nick Starr in a little while to kind of do a fundraiser for the Richard Allen transcripts. Not the girl from Ipanema, Nico. Thank you. In the meantime, though, we are going to go see. We're going to go see Nick Starr at 5. And get ready to help Richard Allen gain some transcripts. We're trying to fundraise to get those because they're not cheap. And I want to, we need to see what happened in that trial, because we were never given the chance to follow along. So I think it's only fair we try to do that. And it's not showing up as available. What the heck? Hold on. No, I don't see it, guys. Damn, I can't find it. Oh, I see it. Yeah, he doesn't can't set it up. So, oh well. Oh well. Can we talk about why Trump hasn't pardoned Matt Hoover yet? That is a shame. Do I mean the Wii Shop music intro? No. No, I don't know what it is. You guys can't redirect. You want to redirect to Kirsha? You guys are funny. You guys are ridiculous. So we're gonna end it here, chat. We're gonna end it here. Oh, I can see where I can send you guys. So we'll definitely send you guys there. So with that said, chat, you guys all take care. And I will see you a bit later today. Will I be joining Nick? Yes. Be joining Nick to raise money for the Richard Allen Chan scripts. David, I'll see you there. I know Hella's going to be there. I know some other people will be there. And then later tonight, guys, 7:30, Runkle has Yannetti and Alessi. It's going to be some good stuff, guys. Really tune in, show Runkle some support, show him some love. Yeah, you can do it. You can do it. So what does this mean for Trump? So you never did reply to my old DMs. I have replied to your DMs. God, you're like my ex-wife, bro. Bruh. We talked about those on the stream. Yeah, anyway, we're gonna keep going, and I will see you guys later. So in the meantime, chat, take care, and remember, until next time, just because you did it does not mean you're guilty. Although for right now, we'll see what happens with Trump in this case. So good night, chat, and take care. I don't think we'll be doing anything afterwards because I assume the thing with Runkle will go for a while. If it ends abruptly, I'll let you know. We may audible. So, Two-Rest, can you post Runkle's channel, please? Yeah. It's let me see here. I'll bring up the link to Runkle's video here. I mean, here you go, guys. This is wow. He's got a epic, l'epique fucking thing. This is the link to Runkle's. This is for 7:30 tonight. Oh, Nick Starro. You guys need Nick Starro's link. Sure, I will. But in the meantime, though, check this out. This is for Runkle's thing. This is a pretty epic. I think whoever does Rob's stuff helps Runkle out, which that's pretty cool. But anyways, that's pretty nice. And then for Nick Starro, let me get him. All right, here we go.
Hey, yo, folks. It is, as I am recording this, it is about 9 hours.
Wait, why is this? Okay, so here is Nick Starro, guys. Here is his webs. Here's his page. And there is this is for Nick's. This is for the Richard Allen stream, guys. If you want to see it, there you go. Baka says, who's Rob? Lawn Lumber. So there you go. That's what we could do. Anyways, guys, he's set to come on. Andrea Burkhart will be there. Bob Mata's going to be there. Remember, Andrea Burkhart went out for the Richard Allen trial. She came all the way out from Washington. Bob Mata went there. they were there the whole time. So yeah, stop by and about 20 minutes, and we will see you guys there, chat. So in the meantime, take care, and I will see you guys then. You guys all have a nice little break, and we'll see you guys. Bye. Oh, why did I disappear there? Anyways, you can hear me. You guys all take care, and I will see you later. Have a good one, chat. Bye.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that hated you?